Welcome to The World Today. I'm waqas Majeed Khan. Well, the topic that we're talking about, how can it be anything other than the aftermath of the Supreme Court's supposedly landmark decision in which the Prime Minister was sent packing home. That is going to be the topic of our discussion today. The criticism that the court has been receiving from various quarters. What is the future course of action? What happened to electoral reforms, judicial reforms, and constitutional reforms as a whole? So we'll talk about all these things. Let me introduce my guests in the studio. Joining me today, we have Kamran Khan Saab, who's a journalist, and along with him, we have Yasir Hamdani, who's a lawyer for his expert opinion on the law. Thank you very much, gentlemen, for being here. Let's get the conversation started. Kamran Saab, in your opinion, what are the implications of the Supreme Court's judgment and the change of the Prime Minister for the democratic evolution of Pakistan? Let's start from a generalized discussion. How do you think it's going to affect democracy and its evolution in our country?
Thank you, Waqas. I must start with with one of the sweeping remarks that the Supreme Court has set a very bad precedent. In the judicial history, we have not seen such precedent in the entire judicial history. There was no direct declaration. Courts did not use any power under Article 184(3) by giving a direct declaration by invoking Article 62 or 63. So we don't have any precedent except in one of the cases, during the era of former Chief Justice Iftikhar Muhammad Chaudhry. He once invoked this jurisdiction and exercised this jurisdiction under Article 184(3) in dual nationality case. You might remember that, where under so many parliamentarians who were holding a dual nationality and they had not declared that dual nationality in their nomination forms at the time of filing of their nomination papers. So the accusation was that they hid their information, they concealed their information, and submitted a false declaration. And so on that concealment, they were declared dishonest and non-sagacious persons, and they were rendered disqualified from being a member of the parliament. So they were in 15 to 20 in number parliament. So that is only one example. Because courts do not resort to or do not step out of its jurisdiction. Article 184 is very clear. Article 184 subclass 3 says that any matter of public importance can be brought directly to the Supreme Court. Any matter of infringement of fundamental right can be brought directly before the Supreme Court. But normally in the cases of qualification or disqualification of a member of a parliament, there is a laid down criteria and laid down procedure. A reference is filed before the Speaker of the National Assembly. Speaker refers to the Election Commission of Pakistan. Then Election Commission adjudicates in either way. Then the appellate jurisdiction arises, and the case appeal goes to the High Court, or then it comes to the Supreme Court. So all these steps and all these stages were ignored, or rather crossed, and a matter was directly. So court do not exercise their jurisdiction under Article 184 to disqualify or to qualify a person.
Right.
They always do not reject. They do not entertain the applications. And
the very presence of Article 62 and 63 has been a cause of concern and controversy over the past many decades. So that's also another issue.
Yeah, the matter is very simple, because Article 62, 63. It says you are supposed to be sagacious, you are supposed to be honest,
Let's get the legal opinion from Yasir.
And I don't know, is there any meter or barometer or a gauge or a benchmark or a yardstick to gauge whether you are honest and how much you are honest, and so it is very open-ended term. That is why all this confusion is arising.
Absolutely. Yasir, what's your opinion?
Right. Now, I first of all agree with what my colleague has said here. it is absolutely clear that the Supreme Court, and it's clear for many reasons, not just the fact that 184.3 was supposed to have a certain jurisdiction in a very special way, but other than that, there was an alternate remedy that was available under the Constitution for people who wanted to get the Prime Minister or any MNA for that matter disqualified. So that procedure is, as he rightly pointed out, through the Speaker. And if the Speaker doesn't act, then it goes to the Election Commission, or for that matter, if the Speaker says that he's not in agreement with the reference, then the reference gets stopped there. This is in line with the fundamental principle called the separation of powers, which is the essential basis of our Constitution. So in terms of 184.3, I thought this judgment was very, very problematic. But other than that, the very issue on which the Prime Minister was disqualified, the fact that there was a spurious, maybe that's not the right word, but a very obscure definition of assets was applied, and which is a very narrow definition. Now, if you're going to use such narrow definitions to determine what Articles 62 and 63 mean, then you would have a floodgate that would open up. You're calling forth a flood, and that is precisely what is happening here. Now we're going to see the same application in other cases as well, and what you've done is essentially given 17 members or 17 Supreme Court justices the power to sit in judgment over the elected National Assembly and elected Senate of Pakistan. This, in terms of coming back to your earlier question about whether this bodes well for our democratic evolution, it does not. Pakistan has been constantly ranked as a hybrid state. The reason why it's not been considered a democratic state is precisely because there are unelected institutions that can ultimately decide whether people have the right to govern themselves or not. So this is a case of where this judgment in particular has cemented non-elected institutions and their supremacy over the one elected institution, that is the Parliament. So I think that this is a very problematic time for our country, and this essentially is a step backwards.
Isn't it strange that it's the Parliament that enacts laws for our country, but it's the justice system or the courts which are dispensing justice in accordance with the laws that have been drafted by the Parliament? So there's this tussle between the supremacy of either the courts or the Parliament also taking place. Kamran Sahab, how is that going to affect the democratic process in the future?
Yeah, this is the basic question, whether the Parliament is supreme over judiciary, or whether judiciary has a supremacy over Parliament. So yes, there is a tussle between the powers. Usually it is said that Supreme Court is creation of Parliament, because Parliament is the legislative body. It makes constitution, and under that constitution, judiciary is come into emergence, and it works even in the parameters which are formulated and which are defined and which are laid down by the legislators and Parliament. So apparently there is a supremacy of Parliament over the judiciary, but unfortunately the case is altogether different.
But the law is the same for everyone.
That is. But I'm saying that there is not a single precedent wherein a judgment or an order of the Supreme Court would be averted or rather declared void by the Parliament. The case is altogether different. There are so many constitutional amendments, there are so many parliamentary acts which were challenged before the Apex Court, and Apex Court entertained the petitions challenging these amendments and parliamentary acts, and they ruled and rather overturned. The recent example is 18th constitutional amendment that is still pending before the Supreme Court, and 18th amendment constitutional amendment was challenged before the Supreme Court, and the Supreme Court ruled over it during the era of Iftikhar Muhammad Chaudhry. It is still pending, for your information. It's still pending, and it was the case that then negotiations started between the judiciary and the parliamentarians, and then parliamentarians were asked to strengthen or to rectify or to amend or to improve the procedure of the selection of judges under the Judicial Commission. So it was limited only to that extent, but there are examples that where under so many constitutional provisions were challenged before the Supreme Court, and Supreme Court ruled over it and asserted its supremacy over Parliament. So it is over. Now we have seen, we have listened to many comments wherein it is said that Parliament should show its stance, should show its muscles against the judiciary, and all such bad precedents should be declared void by the Parliament. Parliament can do it. Parliament can do it, but there we have not seen any movement or such.
Because there's another question that comes to mind, and I'd like Yasir to answer that. Yasir, there were many opportunities previously, and previous governments as well, of maybe repealing Article 62 and 63, saying that that should not be a part of the Constitution. That discussion has also been happening in Parliament as well, but no action was ever taken, and these two parts of the Constitution were kept. So having said that, going forward, do you think that that's going to open a Pandora's box? Now anybody can challenge any sitting parliamentarian and say that this person does not, in my opinion, come on the standards of 62 and 63 and therefore must be removed. So is that going to be the new normal for us now?
Absolutely. I think 62 and 63, the way they've even been used in the past, but after this judgment particularly, you're going to have a sword hanging on every legislator's head. That is how it's going to be. I find it very surprising that people like Imran Khan are now supporting 62 and 63. A few years ago, I heard an interview which he gave with Karan Thapar of India, and in which he criticized 62, 63 as black laws enacted by a dictator, which they are. Now, even in terms of looking at 62, 63, there is also the question of thresholds, right? You can put something in a constitution or a statute, but then you have the thresholds which are determined by the judiciary. With this judgment, what the judiciary has done, unfortunately in my opinion, has determined that threshold to be so low, or conversely so high, whichever way you want to look at it, that basically everyone and anyone can fall under 62 or 63, fall foul of it and get disqualified. So this is a huge issue. Now, as far as this being the legislators did in the past try to amend this, it is very unfortunate that when the 18th Amendment was being passed, this was actually resisted by PMLN and the religious parties, because for some reason they equated this at the time with the Islamic provisions, and that is essentially the argument that the other side makes, is that because there is Article 227 which makes Islamic provisions Islamic provisions as a necessary part of the Constitution.
Is that a part of Sharia law? If we talk about Islamic law, that is Sharia, is Article 62 and 63 in any way, shape or form a part of what the Islamic law says, or Islamic jurisprudence says?
These things have not been determined by a proper judicial forum. Now what we know so far, there is no positive law actually making that determination. But what you have at this time is that if a person, say for example, for any reason whatsoever, if somebody, say for example, owed me money and I did not show it on my balance sheet as an asset, as I could be declared not being Sadiq or Amin. Right? So this is essentially what this judgment has done, and it has done so against the established tax laws. There was a very good story in one of the newspapers yesterday on this particular issue, that the application of this definition is quite erroneous. Now, I think the way forward, and I hope this is the way forward that is taken by all parties, is that there is a review filed and the bench may be enlarged. And enlarged full bench of the Supreme Court, and we're talking about the full Supreme Court, 17 judges should sit down and determine whether this particular disqualification was actually in line with what essentially should happen. So I think that is where this should go. The other thing that I must point out is that it is not very clear whether the Prime Minister has been disqualified for life. I don't see that determination coming out of this judgment, or for that matter from Article 62 and 63. That means that it is entirely possible in theory for Mr. Mian Mohammad Nawaz Sharif to reapply and come back and file his nomination papers on NA 120. And we have Iftikhar Cheema case from last year, which actually did that, where somebody was disqualified and then emerged as a candidate and won the elections. So it is entirely possible, in my opinion, for Mian Mohammad Nawaz Sharif, given the vague and
depending on the review petition, that
exactly, or not just the review petition. I think even with this judgment, it is not clear. So I think he should. My advice would be.
There's a great debate regarding that as well, and I'm glad that you mentioned it, because that was going to be my question. That whether it means that the person who is being disqualified under Article 62 or 63 is banned for life. In certain cases, they say that there is some time limit, and after that they're eligible again. But in certain cases, it's completely up to the interpretation of whom.
Exactly, the Election Commission.
So the Election Commission will decide whether the person has been disqualified for life or whether for a certain period.
Absolutely, because there's no such qualification or disqualification mechanism that is given. I mean, there is a mechanism, but the time period is not given under 62 and 63. Here we have the MNA, in this case Mian Mohammad Nawaz Sharif, being disqualified because he hadn't shown an asset. It is quite logical to presume that he goes back to the Election Commission and says, I've shown all my assets now, hence I am qualified to contest elections again. I don't know why PMLN has actually not looked at this as an option, because this would actually test the logic,
and the limits of Article 62 and 63.
Exactly, and also this judgment.
If you look at the interpretation of these two articles, for example, XYZ, a person who is considered to be who doesn't meet the standards of 62 and 63 today, might be able to meet those standards tomorrow or day after that. So
exactly,
how can you put any kind of time frame on it?
Absolutely, and that's why that is where this law in itself was ambiguous. So
So do you think that we need to go and revisit the Constitution as a whole and then get back to the drawing board and start going through the Constitution with a fine-tooth comb, so that we take out all the extraneous and unnecessary and puerile stuff from the Constitution?
Absolutely, we should. And I think any nation that needs to go forward and progress as a nation must revisit its social contract from time to time.
So when we talk about criminal laws, are we still following the British criminal law system from 1860 or something? Is that a fact?
The Pakistan Penal Code is from 1860.
Made by the British.
Made by the British, but this is the unfortunate part, is that whatever we've added to it is actually more problematic than what was left behind by the British. That is the irony of...
that's a very tragic picture that you're painting for us. Okay, let me move on. Kamran Sab, what are the political implications for the PMLN now going forward?
Before talking about political implications, I must add something to what my learned friend has said. Yes, I think it is lifetime disqualification, because there is a very big difference between the convictions given under Article 162 or 63 or under the NAB law. If you are convicted under a NAB law, or a accountability code convicts you, it says yes, you are being sent to the prison for 21 years, you are being disqualified for a period of 11 years, you are being fined for such and such an amount. So there is a limited, it is mentioned in the statute and it is mentioned in the NAB ordinance that under such sections, such and such sections, these will be the convictions, these will be the punishments, and disqualification period is also mentioned. As we have said, as you have seen in so many cases, many NAB convicts, they underwent their imprisonment, they underwent the disqualification period, and they completed that. And even in the I can quote Yusuf Raza Gilani case. He was convicted, and under that conviction, it has already been determined that this conviction will entail disqualification for a period of 5 years. 5 years or 7 years?
5 or 7, I think that.
I think it was 5.
5 years. 5 years. So it is mentioned, but under Article 162, a direct declaration by the Supreme Court without determining the time frame or time period of that conviction. I mean, obviously it is a lifetime ban,
But that's only obvious to you, sir. Maybe it's not so obvious to me if I'm interpreting this
but you will have to
clause.
You will have to, and Nawaz Sharif will have to again resort to again he will file a review only to that extent to his disqualification period, or he will file another appeal before a competent forum with the pretext that yes, at that time I was rendered disqualified, I was declared dishonest, and I was not sagacious, but now, as you already said, that now I have fulfilled all the, I am meeting the eligibility criteria, and now I am eligible to contest the election. So the judgment of the Supreme Court should
not be
or
considered.
not be. That is why. So this is the main difference. Talking about the political implications, yes, it is. I mean, I will again. Quote my learned friends that this judgment has opened a floodgate in the Supreme Court, because we are living in a very, our political culture is very different. You contest an election, and if you win the election, your rival party will, the very next morning, it will go to the tribunal and file an application for recounting of votes, for it will
accuse them of rigging or whatever.
A number of allegations will be leveled against you before the tribunal. So this process starts. It has become part of our political culture. Now, what will happen? That in a plethora of cases, you will face a number of cases will be brought directly before the Supreme Court. This judgment will be called as a precedent, and registrar office will be asked, no, you are bound to entertain my application, because in that case you had already entertained such, you had already entertained such application to try a person under Article 162 and 163. So there is no, it is bad precedent, and it has really opened a floodgate for the Supreme Court. Today a new Prime Minister will take oath, he will be sworn in, and the very next morning you will see a direct petition will be filed before the Supreme Court. No, he is not a sagacious, he is not honest. You kindly entertain my application and adjudicate his honesty and his sagaciousness. So it is a bad precedent.
But Kamran, another question which is coming to my mind, I'm
and
sorry.
Political implications. I'm sorry.
Before you answer this, because it's part of it, it's connected. Pakistan is functioning without a government for the past 3 days ever since.
Yes, it is vacuum. It is lacuna in the constitution
but
of Pakistan.
If you look at it, right now we don't have any. Nothing has changed.
But you can today if India imposes war on you, I'm sorry, I should not say it. But if such a situation arises, a crisis, who will convene the meeting of the Security Council meeting?
The President?
No. Prime Minister chairs the meeting.
Well, right now everything is under the President's
you
umbrella.
can, but it is lacuna in the 18th Amendment. It is lacuna in the Constitution of Pakistan that even if such a crisis arises, there should be a provision for installing an interim government, for installing an interim prime minister or a caretaker prime minister. There should be a caretaker cabinet.
So Yasir, why don't we have any of that, any of those provisions in our Constitution at all?
Well, first of all, I think that the Constitution did not envisage one institution sitting in judgment over another. That said, there are times where a Prime Minister may be indisposed or may not be available. So I think our Constitution should introduce something like a Deputy Prime Minister and something like a Vice President for the President and Deputy Prime Minister for the Prime Minister.
Isn't it the Speaker in the parliamentary system that takes over that role that
generally does, but I think what we've seen over the last few days has been utter confusion and chaos in terms of where the authority lies. So what we need is clarity on this from the Constitution, especially when you are going to have these unique situations where in the future, more increasingly so, you'll have the Supreme Court dismissing governments. which is the only likely outcome of this situation. So I would imagine that it is very important for us to actually sit down and amend the constitution and have these contingency plans. Also, in terms of the Supreme Court itself, I think one of the long-standing demands in the Charter of Democracy, which PMLN signed with the PPP, was that there should be a federal constitutional court parallel to the Supreme Court. I think that was a very important demand which should have been met, which should have been considered, and they should have reached that by now, because that would essentially create a system where the Supreme Court would be the appellate authority, and then you'll have a constitutional court deciding these important matters arising out of constitution crises that we see from time to time.
Right.
I would like to add something.
Please, Kamran. I was going to come to you anyway, because we also have to talk about the political implications.
Thank you. It was being deliberated by the legislators that there should be a right of appeal against the adjudication under Article 184(3), because if a matter is directly before the Supreme Court and your case is adjudicated and you are convicted in the direct jurisdiction, then you don't have right to appeal in any court of law. In any court of law. I mean, you except provision of review, which has a very limited scope. I mean, 99% reviews are dismissed because the scope of review is very, very limited. Only what is the definition, sir? Only an apparent error floating on the surface of the record. If it is, if such an apparent error is there, then your review is otherwise it is not entertained, and 99% reviews are dismissed by the Supreme Court. So an appeal, right of appeal is not there in the cases of suo motu cases, or in the cases on those cases which are adjudicated under Article 184(3). Same is the case with Nawaz Sharif and his family, that they, after getting conviction by the Supreme Court, by the apex court, they don't have any right to appeal. They can't move any court to hear that we have been convicted wrongly and please listen to our appeal. They don't have any such forum. They don't have any right. So there was a deliberation in the parliament that there should be an amendment in the Constitution of Pakistan, whereunder we could give a right of appeal to those convicts who are victims of Article 184(3). So it was not done, and I must say that politically speaking, I must say that the ruling party of Nawaz Sharif, that was directly responsible for that. You were in the helm of affairs. Why did not you opt for such? I mean, if you would have done it today, you might have been feeling yourself in a very comfortable position. There, your appeal, you have a right of appeal, but it is not in this case.
Yes, of course, there are many unfortunate wishes that may have, or rather wishes were horses.
But that was a genuine demand, because appeal, right to appeal is your, I think, fundamental right.
Right.
Intra-court appeal, I think, is very possible for if you want to introduce it as a constitutional device.
But in Supreme Court, if you are tried under Article 184(3), you are
That's it.
God is in heaven, and that's it.
And that is precisely why the jurisdiction under 184(3) should be used in very exceptional circumstances.
Yeah.
Because you don't want to take away the entire due process, because Supreme Court being an appellate court essentially, then entertaining a matter from the beginning and not giving a right to appeal, which otherwise a person would have. So for example, if Nawaz Sharif was to be convicted by NAB, then he would have a right to appeal, and then it would go through the motions and make its way to the Supreme Court, and then the final decision would come. That is essentially what fair trial and due process is, and that's Article 10A.
And we ignored that completely.
We ignored that completely. And
fair trial, yeah.
Fair trial, I think 10A, for all practical purposes, has been buried after this.
So Kamran sir, if we really go back in just recent history and we see how the chips started to fall for the government, it started with the Panama Papers. So the Supreme Court did not consider any of the findings of the Panama Papers, neither of those offshore companies. Nothing really mattered at the end of the day, except for that one
direct disqualification.
Direct disqualification
on the ground of concealment of facts.
The salary which the Prime Minister did not take. So that is a big question
that
now,
is
because
very strange.
Panama,
That is very strange
Panama
to me.
became a comma, right? So that
is very strange to me. Talking about. I'm talking about.
There
my
were
own but
over 140 odd people that were on that list from Pakistan that were all.
More.
So shouldn't
400.
400.
400, yes.
Well,
more
in
so.
that case, what about the 400? Aren't we?
Yeah,
won't we
Supreme
have
Court can give a
justice
justification.
be delivered to those 400 as well? Are we?
Supreme Court can give a better interpretation that in the case of all those 399 people were not before them. In this petition, they adjudicated on the petition of Imran Khan, Pakistan Tehreek-e-Insaf, and that petition was, the respondents in that particular petition were Sharif family only, the ruling party or ruling family, you can say. So that is, if anyone brings a case, if you file a petition against those 400 people, obviously Supreme Court is now bound to entertain that petition. Supreme Court is now bound to entertain that petition. So yes, that is, and it will entail political implications. And I must say that this is the reason that not only the order of the Supreme Court, or I must say that even judges are being criticized on the social media. We have seen that how come you have convicted a person in a very far-fetched definition of an English word. Black's Law Dictionary, it gives you so many optional interpretations. If you open a dictionary and search the meaning of asset, you will find not a one definite interpretation. There are so many, and the Supreme Court opted a very far-fetched definition to
apply in this case.
To apply in this case to convict a prime minister. And
so are you
they
saying
did not, they did not, I must say that they did not entertain the element of mens rea, or they did not entertain the element of intent. What was the intent of the accused?
Right.
So in criminal jurisdiction,
Absolutely.
it is very, you will support me that it is very important. What was the intent? What was the will? What was the mens rea? What was the mental state? Whether your mental, if your mind is guilty, only then you will be declared guilty.
Right,
Otherwise,
absolutely.
this is criminal jurisprudence.
Right.
And I'm very shocked at how the Supreme Court did not, why it overlooked all these.
That's another
Yes,
very big
see,
question.
If
Kamran sir.
misdeclaration is an offence, if it is an offence, then there has to be an intent for committing that offence. Now, the intent of Mr. Mian Muhammad Nawaz Sharif, I think, is pretty clear. He had actually, with his papers, given the comma. So the very fact that he or whoever was filing the nomination papers on his behalf had a very clear understanding of the fact that this is the income, but I'm not receiving it, therefore it's not an asset. Now this can be, at best, the Supreme Court could have said that this was an unintentional misdeclaration, and you could have asked him to declare that or cure the apparent illegality. But to say that he's not Sadiq or Amin, on the basis,
conclusion derived by that.
It is extraordinary. It's extraordinary because it's after so many months of deliberations on Panama and offshore accounts and London flats and whatnot,
and perjury and
perjury and everything. All of that has gone rightly to the trial court. Right? It has gone rightly to the trial court, but it seems that it was almost forced that they had to declare him.
So you're saying that it seems like a witch hunt?
It seems like a witch hunt to me, and
All right, let's talk about the political ramifications of this in the coming weeks and days. Kamran Saab, now we have tomorrow, inshallah, we'll have a new Prime Minister in the House. Who do you think it's going to be? Do you think Mr. Sheikh Rashid has a chance?
No.
And do you think that if Khan Saab knew that it would be the PTI guy, he would have let Sheikh Rashid?
Apart from Abbasi Saab, all these candidates are just consolidating the democratic process. They have shown respect to the democratic process. Otherwise, they know that they don't have any numerical strength in the parliament. They don't have any chances to win this election. So it's part of democratic process. So they have shown their respect and their willingness to continue with the democratic process, number one. Secondly, again, I must add to the previous discussion that these are the things that now I have even I have seen, I have read, and I have listened to many interpretations like judicial coup, judicial 58(2)(b. So if you talk about coup, you talk about 58(2)(b, which was part of our constitution in the past. So you always, you bent upon declaring someone undemocratic, or you are treated as a opponent of democracy.
Well, if you look at the very position or the seat of the Prime Minister, it is very unfortunate that in our history there has hardly been a Prime Minister who has been able to complete his term. So what do you think is inherently wrong with the Prime Minister's post? There's something seems to be completely amiss, that no individual is able to complete his tenure. Why do you think, what are the causes for that?
And I think this was the longest one term, the Prime Minister, the recent term, which has ended into a so I don't know what is the fault, and fault, dear Brutus, lies not in our stars but in ourselves. I think, quoting Shakespeare.
Right.
So these are things. Yes, some democratic institutions are also responsible for this. This crisis.
How much of it
because,
how much of the blame
why do we give chance to outer forces or some other institutions to step out of their jurisdiction and step in your jurisdiction? So it is
how
your
much of the
fault.
blame do you think we should lay also at the feet of the PMLN in itself and in their performance in the past 4 years in terms of governance? Do you think that there were major issues that needed to be addressed which were not, which is because now we see
To a larger
result?
extent, to a larger extent, I can say, to a larger extent, the responsibility lies on the party, on the Sharif family, on PMLN, because whenever they arrive, I'm sorry to say, whenever they arrive and whenever they come into power, they we have seen a tug of war between the institutions, whether that is military institution, whether that is civilian institution. On one hand there is civil establishment, on the other there is military establishment. And your history is, will tell you how, what happened while dealing with the Musharraf, what happened while dealing with General Jahangir Karamat, with General Kakar. So all these are very sorry chapters of our history.
So what do you see emerging in the aftermath of what has happened in the Supreme Court and the Prime Minister having been sent home? We'll have another Prime Minister from PMLN, and government will continue, a new cabinet will be sworn in.
And I think, and I must
the government
say,
will complete its tenure.
I must say, it must, and it is going to complete its tenure, because the legal
because there are also questions, certain quarters are raising issues or questions regarding calling early elections. Do you think that might be an option that the PMLN might exercise?
PMLN is eyeing for the election of Senate, which are scheduled to be held in March next year, and PML will not go into election before that Senate election, because right now the position is that the PMLN don't have majority in the upper house of the parliament. So they want to regain that majority by going into the elections of March 2018. So before the general election, they will like to have conducted the election of Senate. So that is why this continuity of assemblies, then continuity of tenure is not only in the interest of country, on the nation, but also in the interest of PMLN and even Sharif family.
I think absolutely. I think in terms of completing the tenure, that it must complete its tenure, and we've seen that Prime Minister Gilani went and the Parliament completed its tenure in the last time around. So I think that would be an absolutely a very crucial milestone for Pakistan to have another assembly complete its tenure without any interference, as it were, though even though we know there has been interference, unfortunately. But nevertheless, it would be a remarkable achievement in of itself. I think what is going to happen now in terms of political ramifications of this particular decision, whereas had this not happened, I think we would have headed into elections and they would, People's Party and PTI would have gotten a reasonably, or would have done reasonably better than they did in 2013. That is not going to happen anymore. I think there's going to be a massive sympathy wave that PMLN is going to be the beneficiary of, and we'll see with NA 120, the results in NA 120 will indicate where the country is going in terms of politics. Once PMLN gets its Senate seats, where it has a majority, I think they should move ahead and fulfill some of their promises under the Charter of Democracy. That is absolutely important for the future of the country.
Yeah, absolutely. Now, it's a very difficult situation that we find ourselves in, vis-a-vis the government. Kamran Saab, now, what kind of a future do you think the PMLN is going to have? Yasir thinks that there might be a wave of sympathy that is generated after that, but do you think that it might also be damaging for the PMLN? There might be some desertions, some people who might want to leave the PMLN because they think that the party has been tainted because of the Prime Minister being disqualified. Do you think those are also factors that are going to come into play? What do you foresee?
No. Party is getting strengthened, and with this judgment, yes, party has managed to get mass sympathies. Sympathies are with them, yes, and even whenever the whenever the mandate of public is trampled down, I mean, public always show its resentment and its anger against such orders, such judgments, and such moves. And in this case, we have seen that the Prime Minister who was having mandate of the people, who was about to complete his 5-year term in office, and even elections were due next year, but even then he was made a part of conspiracy, or whatever you may call it. So yes, sympathies are with, and I must say that it is yes, it is a you can say it's a blessing in disguise for the PMLN. But it's a blessing in disguise.
But still,
and you are talking
not clear whether the Prime Minister will be allowed to contest the elections again. That's not clear yet.
But his party will hold the feet. His party will, and the next government will be.
What will be the fate of, let's say, Maryam Nawaz Sharif? She was the heir apparent of the Prime Minister. Do you think that she might be damaged because of this?
It will all depend on what will be the outcome of the references, accountability reference if they get a clean chit from over there. Definitely they will be eligible. There will be no bar against them for contesting election. She will be eligible, and she may become a candidate for the next time in next general election. But apparently, and as I have already told you, that Prime Minister needs to again move the jurisdiction of any competent court. He will file an appeal, and he will ask for the review of the judgment against him only to the extent of his eligibility and his qualification to contest the election.
And I think, just to add here, even if that was not the case, and I think I agree with him that if he goes ahead, there will be this disqualification would ultimately be overturned at some point, from what I can see. But even if that wasn't to happen, then you would have a situation like in Burma, where you have Aung San Suu Kyi. She's still heading the party. She's not qualified, or she's not eligible to hold the office of the president, but she's still there. So that sort of power broking behind the scenes would continue.
But in this case, there is another hurdle for Mia Nawaz Sharif, that he cannot hold the party office. Because if a person who doesn't meet the criteria of Article 62 and 63, he is not allowed under the election laws and Representation of People's Act 1976. under that law, he cannot hold party position or party office. He cannot head the party.
Well, thank you very much, gentlemen, for taking out the time and being on the show and sharing your views and wisdom with us. Well, you heard the conversation, and in conclusion, you have to draw your own conclusions from the conversation that we just had, and let's hope that whatever happens is for the betterment of the country. With that hope, and on that note, it's goodbye.